Howdy, welcome to Patent Law, Week 1, Lecture 1. This is going to be the first of 3 lectures for this first week of class. In addition, there's the reading assignment, which is posted. So you should probably do the reading assignment before you take a look at this lecture, or at least some of the things we talk about in here will make more sense once you've done the reading assignment. So what we're going to talk about in this very first lecture is how you go about getting patent protection for a new invention or discovery or innovation. And the answer is you have to file a patent application. And a patent application entails a number of different parts. You've got your abstract, which is a general description of the invention. And then you have the specification, which has to comply with the requirements in the statute, the Patent Act, and Section 112, that is, it has to provide a written description of the invention, and it has to enable someone of ordinary skill in the art to practice it without undue experimentation, and it has to disclose the best mode, the subjective best mode of the inventor as to how to practice the invention. Of these 3, each is a separate legal requirement. Each must be satisfied, but the enablement doctrine is the most easy to understand. We're going to look at it in more detail later in the course, but for now, what we want is the patent system, if you want to think of it this way, is a quid pro quo. You, the inventor, tell us what you've come up with in sufficient detail so that we can build on it and use it so we're not constantly reinventing the wheel. So you have to give us an enabling disclosure that would enable a person having ordinary skill in the art. This sort of hypothetical person of ordinary skill in the art is our usual test subject in patent law. There are lots of doctrines that can refer to this hypothetical person, but would enable them to practice it. And so you got to give us sort of step-by-step, not necessarily cookbook instructions or precise recipe, but something that a person of skill in the art could take and practice your invention. So you give us your invention in that sense. You teach us what you've learned, and then we give you in return, society, the PTO, the law, gives you in return exclusive right to make, use, or sell that invention for a period of time. Now, at the end of your patent application, you must conclude with a set of claims, and according to the statute, they must particularly point out and distinctly claim the patented invention. Often there's more than one claim, as we'll see. We're going to talk a little bit about claims drafting in this first session, but we don't have you deposit your prototype or a working model or a conceptual model or anything of that sort when we give you patent protection. Instead, you have to write a sentence or a series of claims, but each claim has to be one sentence that lays out precisely what your invention is. Now, in addition to the written portions of the application, the abstract, the written description, and the claims, you also must provide a set of drawings that would enable us to understand exactly what is going on. So if drawings are not necessary to understand, for example, the chemical formulation, drawings are not necessary, but if it's a mechanical device and sort of plans to build it or blueprints for it are necessary to really understand it for an ordinary person of ordinary skill in the art, then you must provide those as well. So to get a sense for that, let me stop sharing this for a second and start sharing a different screen. So as the casebook talks about, when you want to search for a patent, you can go to Google. You can also go, there's a database at the USPTO. There are also other private vendor databases, but you can also just go on Google and enter the US patent number. This is one way to get at it. And so this is Jack Kilby's first patent, or his patent on the first integrated circuit or semiconductor chip, and had a different name, a miniaturized electronic circuit, back in the late 50s when he filed it. And so you can click on that and it will pull it up. And you can see here we have the abstract. And so that's just a general description of the invention and lays out exactly what you're going to be patenting. And you can see here it's in the name of the inventor. The patent always issues in the name of the individual inventor, Jack Kilby. It's currently assigned, though it was assigned all the way from the outset because he was an employee and had agreed to that assignment as part of his employment agreement to Texas Instruments. Now, we're not going to get into the images here or the classification, and then we go into the description or the specification. And so this goes on for a fair length of time. It's a longhand description of what the existing technology is, what the problem with the current art are, and how your technology is an advance over the prior art and solves problems that the prior art currently has. And so it's essentially a sales jingle or marketing brochure about why your invention's great and much better than what we currently ties in and explains the figures involved. And then at the end of that longhand description, again, which much enables someone, a person of ordinary skill in the art, to practice it, you conclude with a set of claims. And so here on the right is the claim from this patent. Now here they only had one claim. Often there's more than one claim, as we'll see, but you have to have one sentence that sort of lays out, sort of starts with a general name for what it is you invented, an integrated circuit having a plurality of electrical circuit components in a wafer of single crystal semiconductor material, and then goes on to lay out the elements. So we're going to be looking at that through the course of today's class, but that at least gives you an idea of where we're going to end up. So when I talk about the patent application, it turns into, if it's approved by the PTO, the United States Patent and Trademark Office, then it turns into a patent, and your patent application becomes the patent. And same abstract, same written description or specification, same set of claims, same set of drawings. Okay. So why a written claim? Why not look at an inventor's prototype? Back in the early part of the patent system, up until the mid-1800s, sometimes we would just look at the inventor's prototype. But we found that a written claim works a little better because sometimes the scientific principles involved or the engineering principles involved that make your invention work could be done in lots of different fashions. And so your prototype may not look like every other version of that invention that would still work based upon your discovery. And so we think a written claim is going to do a better job of that. And so the patent system is actually the one area of intellectual property, the only area of intellectual property, where we require the would-be IP owner to define for us what it is they've come up with. In a copyright system where you write a book or a song or you create a movie or a dance, we just look at your book or your movie or your song or your dance. Same thing with trademark. We look at your word, Apple for laptops or Coca-Cola for soda. We look at the symbols you may use, the apple with a bite out of it, again for Apple, and we compare that to what the defendant's doing. But that's not what we do in patent law. In patent law, whenever I talk about the patented invention, whether I'm talking about validity, is it non-obvious, is it novel, is it patentable subject matter, or I talk about whether the defendant has made, used, sold, or offered to sell the patented invention, what I mean by the patented invention are the words set forth in the claim. And as I mentioned, each patent typically has more than one claim, often has a large number of claims from the very general to the very specific. We're going to look at that in just a minute. Each of those claims is in itself sort of standalone. That is, it could be valid and infringed where the first or the third claim is not valid or not infringed. And so each claim stands on its own, at least as a formal matter as a rule. Now, sometimes a given prior art will invalidate all the claims, or a defendant's product will not infringe any of the claims, but we got to judge it on a claim by claim basis. But that written claim forms the foundation of almost everything we do in the patent system. Okay. So a claim, these are the rules when you draft a claim. It has to be a single sentence. You begin with a preamble where you name the invention in some general fashion. So there was an example of the pencil in the casebook. We're going to look at some other examples in just a minute. Then you pick a word for a transition. There are largely two phrases or words you can use: comprising, which is open-ended, or consisting of, which is closed-ended. So if I say an invention comprising the elements A, B, C, and D together, where I've defined what A, B, and C and D are, that would be infringed. It's open-ended in the sense that if you defendant markets a product that includes A, B, and C, and D, even if it also includes E, F, and G, it's still an infringement. Consisting of is closed, and that means if I say my invention consists of A, B, C, and D together, it's only infringed where a defendant is going to offer that exact product. And you might say, well, I always want to use open-ended, and that's generally right, but sometimes you have to use closed-end in order to avoid prior art. There may be something already on the market that includes A, B, C, D, E, and so you have to exclude element E and say, I'm only patenting the subset A, B, and C, A, B, C, and D together, and not E, because that's part of the prior art. And you can't just list the elements. You have to explain how they tie together and how they relate to one another, as we'll see. But you have to include everything in those listing of elements, A through E or A through Z, that make the invention work, and at least one thing that differentiates it from the so-called prior art, from what we already have. So here's an example. A sandwich comprising, so a sandwich here is our preamble, that's our naming of our invention generally. Then we have a transitional phrase. Here we use the open-ended clause comprising, and then we have two pieces of bread, peanut butter and jelly. So we can't just list the elements. We start maybe with the list of the element, but now we've got to explain how they relate or tie into each other, wherein the peanut butter is spread on one piece of bread and the jelly is spread on the other piece of bread. And then the two pieces of bread are put together so that the peanut butter and jelly are touching. So that would be a claim to a peanut butter and jelly sandwich. Now, obviously, you can't get that claim through the patent office today. It would not be novel. People have been doing this for more than 100 years. So we're not going to give you this patent, but just as an illustration of how to draft a claim, that's an example. Now, again, you could use multiple claims. So you start with claim one. It's an independent claim. It does not depend on or incorporate any elements or limitations or language from any other claim. Claim two here is known as dependent claim. It's written in a fashion that incorporates the element of claim one. So the sandwich of claim one, further comprising, and now I've added bacon, lettuce, tomato, and marshmallow fluff, wherein these ingredients are disposed between the peanut butter and the jelly. Okay, so just as an example, right, could you draft a claim, a patent claim to a shovel? Again, not a novel invention at this point in time, but we're just working on our claim drafting skills to understand what goes into drafting a claim. So you might start your preamble, a digging instrument, consisting of, and so then you got to think of what's going on here. We've got a handle, and then we have a digging head, how we're going to describe that. We can use names, and we can define names in our specification, in our written description. Patentee can be their own lexicographer. They can define terms as they see fit. So if you use a term like a digging head, you can define it, that term in the specification, and then the term in the claim will have that meaning. Now, if you don't define it in your specification, your written description, then we're going to take it to have the meaning that a person having ordinary skill in the art of designing and manufacturing household tools like shovels would give that term. And if that doesn't have a specific meaning, or people of ordinary skill in the art would disagree, your claim may be defective. So here's an example, right? We've got a digging tool comprising, we've got to have the handle and the digging head, and then we got to explain how they connect. So as one possible example, right, we can wait before we get there. Right, we've got to think about how long do we want to say the handle is. If we say a general phrase like a elongated handle, that runs the risk that it might be vague, right? And what does elongated mean? 2 feet, 4 feet, 8 feet? We might be more specific, a handle of between 3 and 5 feet, but then a defendant, another competitor could come along and make one that's 2 feet 9 inches or 5 feet 3 inches, and they would not be within the literal scope of our claim. So we think about these trade-offs, right? The elongated handle may be vague and it may be too hard to understand, but being more specific runs the risk that defendants can avoid the scope of our patent by inventing around, by working outside the literal terms of our patent. So here's an example using the elongated handle. And again, we could define that in the written description, the specification, or we could rely on the general skill in the art to know what an elongated handle, what that term means, how long it might be. So we've got our preamble, a shovel. We've got our transitional phrase comprising an elongated handle having a first end and a second end and a shovel head. Now, again, we either define shovel head in our specification, in our written description, or we rely on a person of ordinary skill in the art to know what that means. And if it's really the very first digging instrument, the very first shovel, we may need to define that term because the person of ordinary skill in the art would not know what a shovel head was because we're the first to invent it. And then we explain how they're connected, right? Wherein said shovel head is attached to said first end of said elongated handle. Now note the use of the indefinite articles and the definite articles. So the first time I introduce a term, a shovel, an elongated handle, a first end, a second end, a shovel head, I have to use the word a or on the indefinite article. Only after I've introduced and defined an element, such as the shovel head, can I use the or said, the more definite article. And so I've already introduced a shovel head, I've already introduced the first end and the elongated handle. So I could switch from the indefinite article, a or an, to a more definite article, either the or said. But you can't do it the other way, the patent office will reject your patent claim. Here's an alternative version of the same claim, elongated handle having a first end and second end, shovel head, which is made up of a neck leading up into a blade. Again, we can define all these terms in our written description, or we can rely on the skill in the art to define these terms if they have an understood meaning in the art. And then we've attached our shovel head to the first end of the elongated handle. Now, again, right, we don't have to only have one claim in our patent application. We can add additional claims to our patent application. These would both be dependent claims, the invention of claim 1, further comprising a grip disposed around said second end of said elongated handle and a grip made of rubber. So we can add additional claims either to improve our chances of sustaining our patent against a validity challenge, or reading literally on what it is the defendant is selling in the marketplace and therefore showing infringement. Okay. Again, though, if we include a term such as an elongated handle, Section 112 of the Patent Act requires that the claims particularly point out and distinctly claim the subject matter of the invention. This is known as the definiteness requirement. They can't be vague or ambiguous, subject to multiple interpretations. And so we would have to ask, is elongated an understood term in the art, so that those who work in this field would understand what links it encompasses. Okay, so that's our first lecture for the first week on claims drafting. The assignment for this week is to draft a claim from the casebook. So after you've sort of read that, take a shot at drafting a claim for yourself, the one assigned in the casebook, and you're going to have to turn that in and post it online by the end of the week.